Easy Maritime Transport Policy and Regulation. Since its inception in 1957, the European Community, or EC, has become a major economic power. Despite its prominence in the international market, where air freight is increasingly common, the majority of EC trade is still carried out by sea. Recent figures show that fully 95% of the external trade and 30% of intra-community trade involve some form of maritime transport. For the EC to retain its status as a world economic power, it must maintain an efficient and competitive community fleet to effectuate its trade. Without a strong and independent fleet, the EC will be subject to pressures from other world powers. In recent years, however, the economic viability of community fleet has decreased as compared to the fleet of non-member nations. Developing countries have aggravated the problem by demanding that a portion of their export trade be carried by their own ship. Because shipping fleets are perceived as state symbols, a decline in community fleets will certainly result in a loss of international prestige. More importantly, however, such a decline will result in a loss of a major source of foreign currency, further reduction of the European shipbuilding industry, and a reduction in the employment of community seafarers. By the 1988 of the EC fleet constituted less than 16% of the world shipping capacity, almost half of its 1970 capacity. It was essential that the community take action to improve its maritime competitiveness. As will be set out in the following section, some action have been taken to address the situation, but more legislation is needed. The objective of this article are as follows. 1. To define the legal framework for community action in maritime matters. 2. To outline the current status of community policy and legislation in this area. And 3. To survey pending legislative proposal which will complete the liberalization program for maritime services within the community. Several provisions in the Treaty of Rome, or EEC Treaty, directly concern maritime transport. The most important of this provision, and the most general, deals with the fundamental tenet of community law, namely the principle of non-discrimination on the basis of nationality. This principle, when combined with other key provisions of the EEC Treaty, authorizes community action in the area of maritime transport. The other relevant portion of the EEC Treaty are the transport provisions themselves, the provision relating to the freedom to provide services, and the competition rules. After the following discussion of the general principle of non-discrimination, each of these provisions will be considered. The principle of non-discrimination. The principle of non-discrimination on the basis of nationality is a fundamental concept in the development of European community law. If a single European community is to be created, it is crucial that member states treat nationals of other member states as if they were nationals of that state. This policy is critical to safeguarding the unity of the EC. The European Court of Justice, or ECJ, has decided that the principle of non-discrimination applies to the creation and application of a common transport policy, as well as to the provision regarding the freedom to provide services and the competition rules in the area of maritime transport. However, the most influential decision invoking the theory of non-discrimination involved the legal controversy over the meaning of Article 84.2 of the EEZ Treaty. That controversy is embodied in what is commonly known as the Code Maritime case. In that case, the member state argued that the Article 84.2 implied that the general provision of the EEZ Treaty didn't apply to sea transport unless the European Council took an unanimous decision to the contrary. These arguments were rejected by the ECG, which stated that whilst under Article 84.2, sea and air transport, so long as the Council hasn't decided otherwise, is excluded from the rules of Title 4 relating to the Common Transport Policy, it remains on the same basis as the other modes of transport subject to the general rules of the treaty. The general rules to which the ECG refers are those concerning non-discrimination. The Code Maritime case held that Section 3.2 of the 1926 French Merchant Seaman Code in its unamended state was inconsistent with French treaty obligation under Article 48 of the EEZ Treaty, which requires non-discriminatory treatment of workers. The French code provided that a certain proportion of the crew of a French ship, as specified by order of the minister, must be of French nationality. After France continued to ignore requests from the European Commission that France uphold its treaty obligation under Article 48 of the EEZ Treaty, the Commission initiated proceedings against France under Article 169. Article 48 provides for the freedom of movement for workers and prohibit any discrimination based on nationality between workers of the member state as regard employment, remuneration, or other condition of work and employment. The French government argued that it had no obligation under the treaty to act in a non-discriminatory fashion since Article 48 didn't apply to workers in the maritime transport sector so long as the Council had not so decided under Article 84.2. The ECG analyzed the relevant provision and concluded that Article 84.1 and 2 allow the application of the general rules of the EEZ Treaty to sea and air transportation. That is, sea transport provision exists on the same basis as other modes of transport and are thus subject to the general rules of the EEZ Treaty until the Council decides otherwise. In other words, the ECG applied Article 48 through 51, which relate to the non-discrimination against and the free movement of workers to maritime transport. The ECG, however, made a distinction between provision regarding the free movement of workers and those related to the freedom to provide services. The ECG relied on Article 61.1, which establishes that the freedom to provide services in the field of transport shall be governed by the provision of the title relating to transport. Because maritime transport services are not included in the general protection of Article 59 to 66, specific action is required by the Council before the principle of non-discrimination can apply to the service aspect of the maritime industry. Transport provision. Article 3 of the EEZ Treaty requires the community to create a common transport policy or CTP to help establish a common market or a single European market. Specific provisions are found in Title 4 of Part 2 of the treaty. Article 74 states that the objectives of the EEZ Treaty with respect to transportation shall be achieved within the framework of a CTP. In order to implement Article 74, Article 75.1 requires the Council to lay down common rules applying to international transport as well as conditions under which non-resident carriers may operate transport services within a member state and any other appropriate provision. Maritime and air transportation, however, are specifically selected for separate treatment. Article 84.2 provides that upon an unanimous vote that the Council may decide whether, to what extent and by what procedure appropriate provision may be laid down for these two modes of transport. Thank you.